Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you leverage your inspiration. This is Wayne Carroll, I'm the host, and today we are talking about trade secrets and specifically the Federal Trade Commission rule that has a date to go into effect on September 4th, 2024, and it will affect every business with employees in the United States. If it goes into effect, there is significant chance that the rule will not go into effect on that date, but we do not have that certainty at this time. So businesses need to prepare. So before I go any further, I want to give a disclaimer. This podcast is for informational, entertainment purposes only. It is not legal advice and does not create any attorney-client relationship. The Federal Trade Commission has been studying non-compete agreements and has determined that businesses don't need them in order to protect their rights sufficiently, and that, on the other hand, that it hurts employees and reduces competition in the marketplace and innovation. In short, the FTC believes that generally non-compete agreements are stifling innovation and slowing innovation because employees with skills that they can take to new employers to bring more innovation are not able to do so because of non-compete agreements. And the rule, if it goes into effect, will make it illegal for an employer to ask an employee to sign a non-compete agreement or make any indication that a non-compete agreement that they have entered into prior can or will be enforced. And on the date it goes into effect or before, employers will need to notify all employees directly by sending them a piece of paper, text, or an email stating that they will not enforce non-compete agreements signed. There's a minor carve-out for executives who are in a policy-making decision in a company and make substantially more than $100,000 over the past year, that those existing non-compete agreements can be enforced because the FTC considers it likely that the executives in those positions actually negotiated their non-compete agreement as part of their compensation. But they don't believe that all the other employees negotiated their non-compete agreement and it was just forced upon them. So this notice will have to go out and say, we promise we will not enforce the non-compete. And even with senior executives hired after the effective date of the FTC rule, you cannot present them with or even attempt to negotiate a non-compete agreement. What do you do? What do you do about all the hard work that you have put into training employees and especially information that they have that you do not want to share and that you have a vested interest in keeping confidential? Here's where companies need to double down on their non-disclosure agreements and trade secret agreements and programs. The FTC specifically carves out and talks about how these are different than non-compete agreements, and therefore they're not going to be part of a non-compete agreement. In other words, if you are enforcing a trade secret, then that is not considered enforcing a non-compete agreement. They are considered separate. Now, we haven't had any court cases to find out how this really plays out, to find out if this whole rule goes into effect and somebody attempts to enforce a trade secret agreement with an employee, that the court will not find that the trade secret agreement is invalid due to the non-compete agreement. So employers need to know about this rule and get into it a little bit. It's not written that complex, but it is written quite broadly. And it's recommended that employers update their employee agreements, their employee manuals and handbooks, and if you're going to keep the non-compete portions in case this does not go into effect, one recommendation is to separate it so it's easier to remove it if this rule does go into effect. Separate the non-compete sections of agreements and handbooks and policies from the non-disclosure, confidentiality, and trade secret policies and such. The second thing is, in doubling down on trade secrets, companies may need to take a closer look at what is their trade secret or trade secrets. There are other episodes I have which talk about what a trade secret is, how to identify them, and how to identify the value that a company has in a trade secret, including, you can see my episode about KFC and how they use their trade secret in marketing and make it known that they have a trade secret, so it's very clear if they were to go to enforce this trade secret that what the trade secret embodies. Enforcing a trade secret generally, just telling a court, I have a secret and it's valuable to us and they can't disclose it, but you don't point to something that you can name, something that you can help the court visualize. What is this secret? That will be difficult to convince the court that this is not just an attempt to do a non-compete through a trade secret if you do not clearly have, if you're not prepared to say, this is the trade secret. Something I can point to, whether it's something you can, that is on a booklet marked trade secret and confidential, or a specific computer program, things like that. Those are what is really important to be able to articulate. And confidentiality agreements, making sure your trade secret and confidentiality education, as well as your security, making sure that you do not provide confidential information to employees who do not need that confidential information. And that confidential information is actually secured physically and electronically so that it is not publicly available, which would destroy the idea that it is confidential. And also being able to articulate why this information is valuable to the company because it is not known by your competitors. For example, your list of your marketing information of prospects that have come to your website, attended one of your events or webinars, have contacted the company. Those lists are things that you have a vested interest in your competition not having. Your list of prospects, your list of customers, and there are many other things that fall into these categories. With this upcoming potential rule, there are court cases that we are expecting may impose an injunction across the United States against the FTC from enforcing this until the case is over, a preliminary injunction. And if that is the case, then we can wait and watch those court cases. If in one case so far, the federal court has not issued a nationwide injunction, but just an injunction against the FTC from enforcing the rule against the defendants in that case, or actually they're the plaintiffs. They sued the FTC saying this would harm our company and we don't think it's constitutional. And so the federal court has said the FTC cannot enforce this rule against this company until the FTC completes this litigation, if they complete it successful. There is at least one other case that We are waiting on the ruling of whether an injunction like that will apply. If it applies, if they receive an injunction, if it applies to just the company or companies that are part of the case, or whether it will apply to the entire United States. Thank you for listening. That's the update and the trade secret information for new FTC non-compete rule. I'm Wayne Carroll, and this is Leveraging Inspiration.